Hello and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. In this session, let us discuss all the important articles from current affairs related to Indian polity which have appeared in the news in the period 10th of December to 31st of December. What are the topics that we shall be discussing today? We have picked up articles from the Hindu, the Indian Express, and the Hindustan Times. Total 7 topics that we shall be covering today. But before we start, an important announcement. You are aware that for the last 2 months, we have been conducting these current affairs sessions or UCAN sessions on YouTube. Every month, 15 classes covering current affairs across subjects, subject-wise, we have been covering for the past 2 months. But then, we faced a backlash from the students who are enrolled with us, and they alleged cheating because we charged them for this course, and their allegation was genuine that you can't make this program free if you have charged us. And we have succumbed to their pressure. Henceforth, all these UCAN sessions shall be available exclusively to our enrolled students on the Unacademy app. Should you wish, if at all you need to wish to enroll for these UCAN sessions, you can enroll separately only for UCAN sessions as well. But I may have a better option for you. As part of our Resolve 2025, which is a new year offer released by Unacademy and which ends today, you can subscribe to Unacademy UPSC courses for 12 months at 23,499. Not only for GS and CSAT, UCAN is already part of it, so that you don't have to separately opt for the UCAN course. Plus, with this subscription, you can get access not only to the classes in the English medium, but also in Hindi medium as well as bilingual. So one subscription covering GS, CSAT, covering English, Hindi, bilingual classes, and UCAN is also part of it. And this is part of our Resolve 2025. And there has been, what I'm told, a 60% discount on these courses. If you can check the website, on that you can see a different price point mentioned. But if you use this code IAS English, you can unlock this 60% discount so that you can enroll for the 12 months course at 23,499. Only if you need it, only if you wish for it. Otherwise, there is no force as always. Let's get started and let's look at topic number 1. No one voice, please. Simultaneous elections. What is this idea? The idea is to synchronize election cycle in such a manner that the elections to the legislative assemblies in the states and the Lok Sabha should be held simultaneously at the same time. That's what we call simultaneous elections. Although this has been proposed by various committees in the past, but this idea has been vehemently supported by the Honorable Prime Minister, then supported by the Election Commission of India as well, and then the central government appointed a high-level committee headed by the former President of India, Mr. Ramnath Kovind, to look into all aspects of simultaneous elections, to suggest if there are some legal, administrative, constitutional changes that are required to implement simultaneous elections. This report was submitted, and this report mentioned that we should have simultaneous elections to Lok Sabha and all the state legislative assemblies at the same time, and then within 100 days, there should be elections to all the local bodies as well. That's the idea of simultaneous elections. A bill to implement simultaneous elections was introduced in the parliament. Obviously, there were a lot of protest, and ultimately, the suggestion of Mr. S.V. Qureshi, who is the former Chief Election Commissioner, his suggestion was that this bill should at least be referred to a joint parliamentary committee. And now a joint parliamentary committee is going to look into the details of this particular bill, which provides for the simultaneous elections. In this lecture, let us look at the arguments in favor of simultaneous elections, arguments against simultaneous elections. We will look at a model question, a prelims-based question that can be asked from this topic, and let's judge whether you will be able to answer that question or not. And then we will also look at some of the mains-based questions which have appeared in the examination from this particular topic. But this article written by former Chief Election Commissioner in the Indian Express on the 14th of December 2024, what this article says is that number one, various suggestions were invited by this high-level committee, but people had the option of forwarding their suggestions only in Hindi and English, which means local languages, other regional languages were not entertained. So the allegation of Dr. S.Y. Qureshi is that such an important exercise, which will have a far-reaching impact on our democratic structure, there has been less number of consultations because the invitations for suggestions were to be only in Hindi and English. That's one criticism. But let's look at the arguments in favor and then against simultaneous elections. But before that, simultaneous polls, according to the bills introduced in the Parliament, will only be for Parliament and state assemblies to begin with. Local bodies have been kept out of the simultaneous election process as of now, according to the bills which have been introduced in the Parliament. Because there are two bills. One which will provide for simultaneous elections to Parliament and state legislative assemblies, and then another bill which will also align these elections for union territories with legislative assembly, Delhi, Puducherry and Jammu and Kashmir. Because Delhi, Puducherry and Jammu and Kashmir, they are not treated as states within the meaning of Article 238 of the Constitution. So as of now, the idea is to hold simultaneous elections only for the Parliament and the state assemblies, not for the local bodies. Now there can be another question. When would this idea fructify? According to experts, this cycle of simultaneous elections can only kick in 2034. Why? Because according to this constitutional amendment bill, when the next general election would be conducted, when is the next general election scheduled? If the current Lok Sabha completes its full term, which means in 2029, on the first day of this new Lok Sabha, which will be convened after the general election, the president will notify a date. And that date will be called as the appointed date. And from that date, this cycle will kick in, which means the president would not say on the first day of the 2029 Lok Sabha that now this Lok Sabha is dissolved and from this date we will have simultaneous elections. That won't be possible. Which means 2029 to 2034, that entire Lok Sabha would ideally complete its term. That means after 2034, we will have that appointed date, and from that date onwards, there can be simultaneous elections to Lok Sabha and state legislative assemblies. Clear? But what are the arguments in favor of simultaneous elections? Argument number one is expenses, which means this exercise would be an economical exercise. A lot of money is spent. Forget about the money spent by political parties to campaign in the elections. A lot of money is spent by the government of India as well, government of states as well, to organize elections. And if it is happening repeatedly, and we have seen instances where every year 5 to 6 state elections are conducted in different parts of the state, on that the expenditure that is incurred, then the expenditure incurred on the Lok Sabha, if we can synchronize the election cycle so that elections to Lok Sabha and state legislative assemblies are conducted at the same time, it will save a lot of money. And according to the high-level committee appointed by the central government, this money can be used for various infrastructural projects. Right now, according to them, it's a wastage. Second, there is something called policy paralysis. And this policy paralysis kicks in because of the implementation of the Model Code of Conduct. As soon as the election dates are announced, Model Code of Conduct comes into the picture, which remains in force till the declaration of results. And during this process, during this period of MCC, no new schemes can be launched, no policy decisions can be made. So the idea is, the purpose is that this policy paralysis which kicks in because of the implementation of the Model Code of Conduct, that we can resolve. We will have MCC only for one election cycle, not repeatedly every year. So we will be able to focus on governance. Third, more focus will be on governance. How? Because ministers, they are busy campaigning for elections. Obviously, the very purpose of a political party is a group of people coming together to form the government. A group of people coming together with the single objective of capturing political power. So political party has to participate in the elections, and through elections, through democratic means, capture political power. For that, they need to campaign, which means the ministers would be busy campaigning in 5 to 6 different state elections every year. Governance takes a hit, and for that reason, we should have simultaneous elections. Fourth, what about paramilitary troops? And teachers. Repeated elections would mean we have to repeatedly summon paramilitary troops to ensure free and fair elections, to ensure order during the elections. And at the same time, we need government employees, particularly teachers, because these teachers are responsible for the election process. They are the presiding officers. They are the election officials. Ultimately, what we can do is have the election cycle only once every 5 years, so that for the remaining part of the 5 years, these teachers and paramilitary troops can focus on what is mandated from them, which is to ensure peace, which is to teach the kids. Also, fatigue. Voters. Voters will have to vote in the parliamentary election, then vote in the state assembly elections as well. So there is an element of fatigue. That is why perhaps the voting percentage is low. And that is the reason why we should have simultaneous elections. So that once in 5 years, they enter the polling booth, one vote for MP, one vote for an MLA, problem solved. Voter fatigue will be taken care of. Caste and communal conflict. Just before the elections or during the elections, we see polarization happening on the grounds of caste, on the grounds of religion, sometimes on the grounds of language as well, because the political parties will try and vitiate the atmosphere, fish in the troubled waters, look at the cleavages of our society and try to polarize the society. And to ensure that such things do not repeat every year, because elections in Lok Sabha, then we have 5 to 6 state assembly elections every year. It is as if we are in a continuous cycle of elections. And if we are in a continuous cycle of elections, then caste and communal conflict also becomes the order of the day. Let's do it once so that we can have caste and communal conflict only once. Maybe that's the idea. Seventh, money and muscle power may reduce. Political parties spend money to lure voters. And if they spend money to lure voters, ultimately they have to do it multiple times, which means in Lok Sabha as well as state assembly elections as well. The idea is that if we will have simultaneous elections, voter turnout will increase. When voter turnout will increase because they will have less fatigue, they will come out in large numbers once every 5 years to celebrate the festival of democracy. When everybody will come out to vote in large numbers, the money that should have been spent by political parties to lure these voters, now they have to massively increase that expenditure, massively increase that amount of money to bribe the voters, which these political parties will realize later that they won't be able to do it. So simultaneous elections, the unintended consequence would be that money and muscle power would be reduced. How? Let me explain this point. Today, political parties have to spend money first to lure voters so that they can come out of their homes to the polling station to vote. So first we have to lure them to come out of the homes, which means the political parties know that not everybody will come out to vote, which means they will have to spend this amount of money, X amount of money, to lure people to come out of their homes to cast their vote. Because of simultaneous elections, there will be less voter fatigue, because everybody will be looking forward to this festival of Indian democracy every 5 years, which means now majority of the people will come out, voting percentage will increase. And since people in any case are coming out to vote in these elections, political parties need not bribe these voters. Maybe political parties will still need to bribe voters to vote for them. They don't have to only bribe voters so that they come out to vote. They need to bribe them so that they vote for them. But they will also realize that the amount of money to bribe everybody would be humongous. And it is not practically possible to bribe everybody. So the unintended consequence of simultaneous elections would be voter turnout increasing and money and muscle power would also reduce in the elections. But there are those who are highly critical of this idea of simultaneous elections. Why are they highly critical of this? On one ground, they say that you are overestimating the economic angle or economic impact or aspect of simultaneous elections. How? According to the budget estimates, because after all, money is to be given from the Consolidated Fund of India to Election Commission of India to organize these elections. Yes, when elections are conducted, for example, Lok Sabha elections, a part of this money is contributed by the states as well. When there is a state assembly election as well, a part of this money is contributed by the state as well. According to Mr. P.D.T. Achari, who was the former Secretary General of the Lok Sabha, he said that the amount of money that is used by the government to spend on Indian elections for the last Lok Sabha was only 466 crores. 466 crore is peanuts. And for this reason, if you want to save a part of this 466 crore, for that you want to conduct such a massive exercise, it makes no economic sense, according to Mr. P.D.T. Achari. Similarly, argument number 2 is, who asked for it? In a democracy, the demand for any reform should come from the people. But are there people asking for simultaneous elections? Or is this idea coming from the ruling political party at the center? The majority of the money which is spent in the Indian elections comes from donations by corporates to political parties. Even they have not asked for simultaneous elections. Rather, they should have been asking for it. That we should not be paying political parties money every year. We should give them money once in 5 years. After that, our umbilical cord is cut. They have never asked for simultaneous elections. So who asked for it? Plus, when you are overestimating the economic impact of simultaneous elections, you are underestimating the impact on economy. Because of periodic elections. Dr. S.V. Qureshi, who has written this article, he writes in his book, Elections in India, an Undocumented Wonder. In that book, he says, It's the people who want periodic elections after every period, because जब जब देश में चुनाव आता है, गरीब के पेट में पुलाव आता है. So during this election cycle, there are restaurants who are abuzz with economic activity. Printing presses, they are abuzz with economic activity, because elections give employment to a large section of people. Some will be involved in printing manifestos. Some will be involved in printing election propaganda material. Some will be involved in designing the flags or pamphlets or hoardings. So if elections are held periodically, forget about the money that the central government or state governments may save because of simultaneous elections. But look at the economic impact on the poor, on the marginalized communities, if you go for simultaneous elections. Because elections happening every year would mean every year there will be economic opportunities for people who are associated with the election process. Fourth important point, what happens to the accountability? Accountability may be reduced. For example, I am a minister at the central government, or I am part of the ruling political party at the center. We make few mistakes, and we have made a few mistakes here and there, whether with economy, whether with caramelized popcorn. Then the people will punish us in the next legislative assembly election. So immediately we can do course correction. We can correct the wrongs which we have committed. But if elections are not held periodically, because we have made mistakes at the central government level, so when elections would be happening in a state, there the people might punish us. So we will be accountable to the public every period, after every period, in every election cycle. So regardless of whether you are saving money or not, but the accountability of legislators to the people will reduce. That is the biggest impact of simultaneous elections. There are other concerns raised by some, and I don't agree with their criticism. And there are possibly two such criticisms I don't agree with. One is that it will be an assault on federalism. Second, national issues shall dominate local issues. I don't agree with these concerns. Why? And I'll tell you the reason. One impact of simultaneous elections, as the critics point out, is that it will be an assault on federalism. In a sense, that you are aligning the term of the Legislative Assembly with that of Lok Sabha. So basically, you are making Legislative Assemblies subservient to Lok Sabha. But that's not the case. Legislative Assemblies will not be subservient to the term of the Lok Sabha. The term of Lok Sabha, Legislative Assembly, will be 5 years. It is only in the initial cycle, when you have to implement this idea, that some of the legislative assemblies, they might see a truncated term. Their term would have been for 5 years, but to align with the term of the Lok Sabha, they might see truncated term of 3 years. That's it. That will happen only for once. After that, even if the government falls at the central level and the Lok Sabha is prematurely dissolved, and if election is conducted to Lok Sabha again, it will only be for the remainder of the term. It's not that with the dissolution of Lok Sabha, you have to dissolve all the state legislative assemblies. That would have been an assault on federalism. But that's not the case. Even if there is a premature dissolution of Lok Sabha, when new Lok Sabha is convened, when new elections are conducted, their term will be, the term of the Lok Sabha will only be for the remainder of the period, which means not for 5 years, but for the remainder of the period left. So how is this an assault on federalism? I'm unable to understand. But don't call me the supporter of the government. I'm just telling you the facts. Second, national issues shall dominate local issues. This is like people considering that Indians are immature and foolish, and they would not be able to differentiate between a national election and a state election. We have had repeated instances, for example, in Delhi, for example, in Odisha, for example, in multiple different states, where elections were held simultaneously to Lok Sabha and the state legislative assembly. But people voted differently for Lok Sabha, voted differently for legislative assembly. People voted overwhelmingly for BJP in Lok Sabha elections in case of Odisha in 2019. But for state assembly elections, at the same time, they voted for BJD. 7 out of 7 seats in Delhi were bagged by BJP in 2019. But then in 2020, when legislative assembly elections were conducted, 62 of the 70 seats were bagged by the Aam Aadmi Party. So people in India, they're politically very aware, very conscious. So this is like undemocratic paternalism, where some people advocate that if simultaneous elections are conducted, national issues will dominate state issues, or regional political parties will be thrown out, and then the central parties or the national political parties will control the narrative. That is not going to happen. And if that was the case, then our original scheme was also anti-federal. Because right from 1952 till 1967, elections would be conducted simultaneously to Lok Sabha as well as state legislative assemblies. This cycle of simultaneous elections got broken because of the misuse, overuse, abuse of Article 356, where although the term of the Lok Sabha was 5 years, term of the Legislative Assembly was 5 years, elections were conducted simultaneously, but then some state governments were dismissed unconstitutionally, arbitrarily by the central government imposing Article 356. That's how the cycle of synchronous elections, simultaneous elections got broken. So if the original intent was not against federalism, how can we say that if we are now going back to the original intent, it will be anti-federalism? This is where there is an interesting article written by Mr. C.R. Keswan in the Hindustan Times, although the spokesperson of the BJP, but he makes some valid points. He says, in the Constituent Assembly, some of the brightest legal minds debated for more than 2.5 years, for 2 years and 11 months, to debate and frame the constitution of the independent India. They debated everything, right from whether we should have universal adult franchise, whether there should be discrimination on the grounds of religion or caste, whether we should have a parliamentary democracy or a presidential form of government. They debated everything. But one thing which was conspicuous by its absence, was Constitution did not talk about simultaneous elections. What could have been the reason? The reason could have been that the founding fathers of our republic would imagine that this is logical thing to do. You don't reiterate something which is obvious. And if we are to have elections in Lok Sabha and state legislative assemblies, it is natural, it is obvious that elections should be conducted simultaneously. And that is how in 1952 till 1967, election was conducted simultaneously. 1971, Lok Sabha was prematurely dissolved by the president on the advice of the Prime Minister. Srimati Gandhi was the Prime Minister. And that's how the term of the Lok Sabha also got shifted. So Mr. C.R. Keswan argues that our constitution creators probably felt that a synchronous cycle of simultaneous election was natural way forward, thus would be retained. And Mr. Keswan writes that after the revocation of the special status for Jammu and Kashmir, because previously Jammu and Kashmir would have its own constitution, now we have one nation, one constitution. We have one nation, one tax, indirect tax in the form of GST. Now don't ask me about what about popcorn, that you will have to ask the finance minister. But we have one nation, one tax. We have one nation, one ration card. We have one nation, one subscription now. We have one nation, one health card. And now we should have one nation, one election as well. And this is not against federalism. This is cooperative federalism. Okay? But one thing which I personally don't like is that if you wanted all these advantages, then shouldn't it be logical that we should have simultaneous elections to Lok Sabha, Legislative Assembly and local bodies as well? But that's not going to happen. Second, even if we go by the recommendations of the Ramnath Kovind Committee, there should be simultaneous elections to Lok Sabha and Legislative Assembly, and then within 100 days to local bodies. Don't you think it is this which will cause voter fatigue? Because I voted previously, now 100 days later, I have to vote again for Panchayat and local bodies. So the purpose should have been to implement simultaneous elections across the 3 levels of the government, if at all that is the objective. But let me ask you a question and see how many can answer this correctly. Which of the following statements is or are correct? The high-level committee on simultaneous elections, headed by former President Ramnath Kovind, was constituted to study the pros and cons of holding simultaneous elections in India. Second, to implement all the recommendations of the committee, a constitutional amendment would be needed without ratification by half of the state legislatures. Which of the statements is or are correct? Tell me what is the answer. I can see 3 to 4 correct responses, but otherwise most of the students are wrong. The high-level committee on simultaneous elections, headed by former President Mr. Ramnath Kovind, was constituted to study pros and cons of holding simultaneous elections? No. The terms and conditions of this committee was not that please check what are the advantages, what are the disadvantages of simultaneous elections, and then recommend whether we should go for simultaneous elections or not. No. The terms and the conditions were that we want to go for simultaneous elections. Now you tell us, what are the administrative, what are the legal, what are the constitutional changes that are required? If we implement this, do we need constitutional amendment? If we implement this, do we need constitutional amendment with ratification by at least half of the states? That was the terms and conditions of this high-level committee. It was not tasked to study our pros and cons of simultaneous elections. No. Now, second point, very important, to implement all the recommendations of the committee. Now, some recommendations of the committee do not need ratification by half of the states. For example, the current bill which has been introduced in the parliament, it does not need ratification by half of the states. But if we want to implement all the recommendations of this committee, then you need ratification by half of the states. Which is that recommendation? Recommendation of this committee is we should have one common electoral roll. Sir, we have a common electoral roll, but one electoral roll for Parliament and State Assembly elections prepared by the Election Commission of India. But the electoral roll for local body election is prepared by the State Election Commission. One recommendation of this committee is there should be a common electoral roll for all the 3 tiers of the government, which should be prepared in consultation with the State Election Commission. For that, we need a constitutional amendment, and that too with ratification by at least half of the states, because that's a federal feature. Local government, in the distribution of legislative subjects under Schedule 7 of the Constitution, deals with state list. Entry 7 of the state list deals with local government. And if you want to synchronize local elections with that of Lok Sabha and State Assembly, that requires a constitutional amendment with ratification by half of the states, because that is a federal feature. Okay? Very good. Then this is the question which was asked in Mains 2017. Simultaneous elections to the Lok Sabha and state assemblies will limit the amount of time and money spent in electioneering, but it will reduce the government's accountability to the public. Something I was talking about here. What about the accountability of the legislators to the people? Periodic elections means more accountability because you have to go to the people every now and then. Otherwise, you are voting for somebody and for 4.5 years, 5 years, that person, that representative is not seen at all. And after 5 years, suddenly this person appears begging for votes. That will reduce accountability, and that is why perhaps simultaneous election is not the right panacea for the problems that we have. Let's look at another topic, a real basic structure question written by Pratap Banu Mehta. Once President of United States Barack Obama said, with reference to Dr. Manmohan Singh, who was the Prime Minister, that when Dr. Singh speaks, the world listens. Similarly, when Mr. Pratap Banu Mehta writes, you should read. One of India's most important, brilliant political scientists. This topic would be relevant also for those who have political science and IR as an optional, even for those who have sociology as an optional. But I will restrict the discussion on this topic for the GS perspective, for polity perspective. There was a debate on the Constitution in the recently concluded winter session of the Indian Parliament. Mr. Pratap Banu Mehta argues that Constitution's main task is to protect individual dignity. Can it do so in the face of ascriptive identities? What does that mean? American sociologist Talcott Parsons, he was a structure functionalist, and I don't need to explain what structure functionalist is because that's not the domain of GS. If you're a student of sociology or PSIR, you would know. Very briefly, according to Parsons, every structure has a function, which means a function to create order in the society, to maintain order in the society. And according to Parsons, individuals have two kinds of status. One is an ascribed status, and the other is the achieved status. What is an ascribed status? Something that you are born with. For example, your religion is ascribed to you at the time of the birth. Your gender is ascribed to you at the time of the birth. Your race, your ethnicity, something ascribed to you at the time of the birth, which is something that you get because of the accident of birth. But then, despite the fact that you may belong to a particular race or ethnicity or religion or caste or gender, but through educational qualification, through luck, through chance, you may achieve something. You may become a doctor, a professor, or a politician. So you achieve something because of your merit, because of your educational qualification. So one is the ascribed status, the other is the achieved status. Now keep that in mind. I will come back to this differentiation in a moment. Pratap Banu Mehta argues that the beauty about the framers of the Indian Constitution was that our Constitution did not burden itself with the questions of faith, history, and identity. Constitution should be there for everybody, regardless of your ascribed status, whether it is religion, whether it is caste, whether it is place of birth, whether it is residence, whether it is gender. Our Constitution does not worry about our history. It is forward-looking. History in the sense, the colonizers, they segregated our history into Hindu history, Islamic history, Christian history. And that segregation, some historians say, is the root of all the problems that we witness today, where you are dividing history on religious grounds. Hindu history, ancient India. Islamic history, medieval India. colonial history, Christian India. And whose faith? Your faith, my faith. Constitution does not deal with that in a sense. Constitution creates a society where state does not have its own religion. It does not get into this argument of whose religion is better. Constitution that way is forward-looking. And why did the framers of our constitution not burden the constitution with the questions related to faith, history, or identity? That does not mean that these questions are unimportant. Because these questions are important, that is why they did not deal with this. Why? Because makers of our constitution thought that these are so important questions. For them, we have to create conditions so that we can freely come to judgments about these matters. What is the identity? What should we do with this identity? For that, there should be a free discussion in the society. That's something that you can't paint in the constitution forever. The crux of our constitution is constitutionalism. And what is constitutionalism? You can look through the idea of constitutionalism from the theories of John Locke and other contractualists. What does that mean? Listen to me carefully. If people were angels, there was no need to control people or govern people because angels can do nothing wrong. In contrast, if the ruling class were angels, then you don't have to worry because the ruling class will not do something which is immoral, unethical, illegal, unconstitutional because they are angels. But neither are the politicians angels, lawmakers angels, nor are the people. Now this is a tricky wicket for constitution. First, it has to empower the state. And then it has to impose limitations on the state. It has to first empower the state that you have the power to govern the society and ensure order in the society. And then at the same time, the same constitution has to impose limitations on the state so that the state does not become a tyrant, does not become an arbiter authority. And this is where the idea of constitutionalism comes into the picture. Constitutionalism means government should be and must be limited in their powers. And that's what we call doctrine of limited government. The government should be and must be limited in their powers. And the legitimacy of the government will depend upon whether it is observing these limitations or not. That is why if the government is flouting constitutionalism, we say that this government is illegitimate because it is not observing the limitations imposed on it by the constitution. But how does our constitution believe in constitutionalism? What is the core aspiration of this constitutionalism? Separation of powers. James Madison, former US president, he says, concentration of all powers, whether administrative, legislative, judicial. If we concentrate all powers in one body or one individual, it can be pronounced as the worst definition of tyranny. So you can't concentrate powers in one individual. For that, you need to separate the powers. One power to the executive, one power to the legislature, these powers to the judiciary. Because if powers are not separated, then how can we limit the powers of the government? Because then the powers of the government will be unlimited. You will be the judge, jury, and the executioner in your own case. That is why legislature will make laws. Executive will implement laws. And judiciary will sit on the judgment whether the actions of executive and legislature are constitutional or not. So that one organ does not become so powerful that then there is no check on that institution, on that body. Isn't that constitutionalism? Popular sovereignty lies with the people. Even if you think that this government is illegitimate, or the government is not upholding rule of law, or the government is taking arbitrary decisions, or the government is violating the peace of the society, you can vote that government out of power after every periodic election, because ultimate power lies with the people. So people keeping a check on government. What is this constitutionalism? Rule of law. Nobody shall be sentenced in body or goods except for a breach of law. If you are a law-abiding citizen, you don't have to worry about police or any other institution, because you have not committed any crime. When you have not violated any law, you have not committed any crime, why should you worry about the state and its powers? Don't be worried about the police or the judiciary or the legislators. But despite not committing any wrong, if you're still worried about executive, that means executive is not following rule of law, because then you can be arbitrarily detained. But since we follow rule of law, that means it's a check on the government. Constitutionalism. And even if there is violation of separation of powers, if the government is not organizing elections, if the rule of law is getting violated, there should be an independent judiciary, and you can knock the doors of the independent judiciary, and judiciary will restore your rights, because these rights also are limitations on the powers of the state. How? Look at the fundamental rights chapter. The state shall not deny equality before law or equal protection of the laws. The state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this. The state shall not do that. These rights are what? Limitations on the powers of the state. That's constitutionalism. And Pratap Banu Mehta argues that the fundamental challenge is to ensure that this constitutionalism, we have to be vigilant towards. We have to be aware, vigilant towards all those forces that subvert this aspiration. That's the real basic structure. "24th of April, 1973, a 13-judge bench of the Supreme Court in a landmark case, Keshavananda Bharti versus State of Kerala, ruled that yes, Parliament has the power to amend any provision of the Constitution, but not the basic structure. When the Constitution was being debated in the winter session of the Parliament, Congress attacked the BJP, BJP attacked the Congress. Pratap Banu Mehta says that is a diversion. Forget about that. The real basic structure question is that this is constitutionalism. And we have to be vigilant towards those who want to subvert this aspiration. That's the real basic structure. Something else. American political scientist Francis Fukuyama, of Japanese heritage, but then he's an American citizen. He wrote about the end of the history. Pratap Banu Mehta argues that there is a joke amongst jurists that it was not Francis Fukuyama who pronounced the end of history. It is our Supreme Court in Keshavananda Bharti. How? Francis Fukuyama, for example, he said, just like Karl Marx, let me deviate a bit. Otherwise not required, but let me deviate a bit. Karl Marx, he spoke about cyclical nature of history. That history started with primitive communism, then ancient society, then feudal society, then capitalist society. And then there will be a revolution through which we will enter into a preparatory stage called socialism. And once socialism will mature, we will enter communism. And communism will be a stateless society where the state will wither away. So there is a cyclical nature of history. We started with primitive communism. Our history will end in communism. So this is where the history will rest, according to Karl Marx. Francis Fukuyama says, after the Cold War period got over, he wrote a beautiful book in 1992. When the Cold War period ended with the dismemberment of the Soviet Russia in 1991, Francis Fukuyama argues that now the history will rest. According to Karl Marx, it will rest in primitive communist state. According to Francis Fukuyama, the history will end with the Western liberal democracy. Because after all, the clash between Soviet Russia and US was on the idea of whether there should be capitalism, free market, liberalism, or whether it should be state-controlled socialism. And with the dismemberment of USSR, with the collapse of the USSR, with the end of the Cold War, Francis Fukuyama argued that the history will end now with every single country embracing the Western liberal democracy of the West. Pratap Banu Mehta argues that if Francis Fukuyama predicted the end of history by saying that it is the world will now embrace the Western liberal democracy, maybe that's not the case. The history was declared to be an end by our Supreme Court, because in 1973, Supreme Court said there is something called basic structure. Because it is this basic structure doctrine which puts constitution out of time. Basic structure can never be changed. In a sense, history has been arrested. Now it is in this horizon that we have to keep on moving. Yes, changes will be made to the constitution, but subject to basic structure. And Pratap Banu Mehta argues that it is this basic structure which has now become our Sanatan Dharma. But the beauty of the argument given by Pratap Banu Mehta is this. Modern democracies everywhere in the world, they rely on legality to derive authority. Legality in the sense, modern democracies, for example, US, France, Australia, the constitution of these countries, they derive authority from the people. Just like our constitution, our constitution also derives its authority from the people. That's how the preamble starts. We, the people of India. That means the source of authority from which the constitution derives its authority from is the people of India. And then purely like a legal document, constitution decides and allocates roles and responsibility. These are the rights available to the people. This is the job of the legislature. This is the job of the executive. This is the job of the judiciary. So constitution can be viewed as a purely legal document. Constitution does not identify individuals. Or in a sense, we can say constitution does not discriminate against individuals. Or constitution does not look at individuals as a group. The core essence of the constitution is to uphold individual liberty. So constitution will treat individuals, people as individuals. Not that you belong to a particular group or a particular sect. You are treated as an individual. This is where Indian constitution makes a concession. Although we are also having a legal document in the form of constitution. Look at the beauty of this point. We are also governed by this legal document called the Constitution, which ideally should not have looked at people as groups, but as individuals. And we need to uphold your individual dignity, freedom, liberty, thought, justice. But Constitution of India, it gives a concession on the grounds of caste. That means it is a social form that has to be represented. Now, individuals are given what? Constitution legalizes their ascribed status. Calcutta Parsons, ascribed status, achieved status. Constitution should ideally not look into groups, identify groups, or give support to groups, or give credence to groups, but individuals. Individual liberty has to be upheld. But this is where we make a concession on the grounds of caste. And because of that recognition on the grounds of caste, we have created a sense of permanent ascript to majority and minority. Because your ascribed status cannot be changed. You are a Dalit, regardless of the fact whether you are a B.R. Ambedkar, you are a doctor, you are a philosopher, you are a Dalit. And now this identity, this ascribed identity, is now a permanent marker for you. And when it is a permanent marker for you, that means we have also created a permanent majority and minority. And now it is this minority which is demanding that this constitution, which should have been a legal document, which should have had a legal form, it should have a social force as well. And that is how our constitution, it recognizes this caste by saying there shall be equality of opportunity and reservation for marginalized communities in government jobs, in educational institutions. So the irony, according to Pratap Banu Mehta, is that the constitution itself has created this permanent ascribed status along the lines of caste. Whether we survive this contradiction is a constitution which was meant to liberate individuals, which was meant to look at individuals. And now these individuals are pushed into ascribed identities based on their birth, and that is a permanent marker of their identity. And how can we survive this contradiction? That is an open question according to Pratap Banu Mehta. Let's wait and watch how do we recognize this or reconcile this. From this particular topic on basic structure, a question was asked in Prelims 2020. Let me see how many people can answer this question. The Constitution of India defines its basic structure in terms of secularism, federalism, fundamental rights, and democracy. The Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. Which of these statements is or are correct? Let me know what is the right answer. A lot of people giving the right answer, which I can assume a lot of these students are my students. Navid, unfortunately, is my student, but he has made a mistake here. Does Constitution of India define basic structure? Simple answer, no. Because that is something which has been innovated by the Supreme Court in the Keshavananda Bharati judgment. So basic structure doctrine is a judicial innovation. Constitution of India provides for judicial review. Again, this is incorrect. Because this concept judicial review is not mentioned in the Constitution. Constitution does not explicitly talk about judicial review. No. Judicial review as a phrase, word is not mentioned in the Constitution. But we can trace the concept of judicial review to Article 13, to Article 32, to maybe Article 226 as well. For example, Article 13 says, state shall not make any law to delete, abridge fundamental rights. And if the state goes ahead and enacts a law to delete, modify, abridge a fundamental right, then that law shall be declared void. And the implication is that legislature cannot declare it void because legislature has enacted this law. Executive also will not do that because executive is drawn from legislature. The only other organ which is left is the judiciary. So it is the judiciary who has the power to strike down a law in case constitution is violated, in case fundamental rights are violated, in case part 3 of the constitution is violated. But Constitution of India does not provide for judicial review. Yet judicial review is part of the basic structure of the Constitution. So D is the right answer. Okay. Then from this topic, a question was asked in Mains 2019 as well. Parliament's power to amend the Constitution is a limited power. Limited. And it cannot be enlarged into absolute power. In light of the statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure by expanding its amending power. It cannot do that, but for that you have to write an answer. And write this answer by citing case laws, such as Minerva Mills, such as Vaman Rao, such as I.R. Kolo, and various other judgments. But that is something for your practice. Okay. Now let's look at another topic from the Indian Express, impeachment of judges. Although impeachment is not a word to be used for the judges, Constitution of India uses the term impeachment only and only for the President of India under Article 61. Every other functionary, whether it is Vice President, judges, CAG, CEC, the chairperson of the UPSC, they can be removed from their offices. Impeachment is used only for the President of India. But be that as it may, that's one clarification. Second, one High Court judge, a judge of the Allahabad High Court, was addressing some people at an event organized by the VHP, Vishwa Hindu Parishad, made some disparaging remarks towards a minority community while he was advocating for a uniform civil court. He was then called by the Supreme Court Collegium, and he was also asked to be careful in future. This is not something that you should have spoken about. Why? Because it then gives a sense that you will be biased in your judgments. And then efforts were made by the MPs of Rajya Sabha that we want to remove this judge. And this article talks about how the judges can be removed in India. Dr. B.R. Ambedkar, he was asked, what do you think is the most important office under the Constitution? He said the office of the CAG, Comptroller and the Auditor General of India. After that, judges. But these judges should also be independent in their functioning. Independent in their functioning means multiple things. One commonly understood concept of independence of judiciary is that judiciary should not be influenced by the other organs of the state, such as executive, such as the legislature. So while giving judgments, while hearing cases, judiciary should not come under the influence of either the executive or the legislature or other organs of the state. But that is one form of independence of judiciary. There is another implication, or should we say two other implications. Independence of judiciary should be that judges should be independent of their own biases. For example, I am an individual who is homophobic. For example, I'm not, I'm just giving an example. That I don't like members from the LGBTQIA plus category. But now I am a judge. And when a case appears before me, where a member from this LGBTQ community has alleged torture or mistreatment or discrimination, should I apply the law of equality, the principles of equality, the principles of justice? Or should I use my own bias because I hate them so that I will not give justice to them? That's independence of judiciary. Independence of judiciary is not only that judges should be independent in their functioning and they should not come under the influence of the executive or the legislature. The judge should be independent of his personal bias as well. And the independence of judiciary also means media and society. Media and society in the sense, there is a trial by media. For example, many years ago, there was one boy from the Sikh community who was riding a motorcycle and one lady claimed that he had harassed her. The media immediately latched onto the story and said, Delhi ka darinda. He lost his job, but then he fought valiantly and he proved his innocence. That girl went to Canada. She was summoned multiple times. She did not come. So there is trial by media. And as judges, should we be influenced by the trial by media and give our judgment based on the collective conscience of the society? Or should we give judgments based on the collective conscience of the law? Society may demand anything. That here is a particular person who is a rapist. How should we deal with rapist? Even if you are guilty, how should we deal with you? Yes, we can give you death sentence. Yes, we can give you life imprisonment. But should we throw you into a ring so that the hungry tigers and lions can pounce on you and kill you? That was the form of justice which was supported by the people in the Roman Empire. Or should we chemically castrate these rapists who have been proven to be guilty? But that may not be the ethical treatment. So we don't have to look at what is the collective conscience of the society. We have to look at what is the collective conscience of the law. That's independence of judiciary. This is where Constitution said we should give independence to judiciary. And how Constitution envisaged independence for judiciary? Constitution said you are not holding offices during the pleasure of the president. Once you're appointed, you will remain in office till the age of 65 if you're a Supreme Court judge, 62 if you're a High Court judge. Your conduct cannot be discussed in the parliament unless and until you are bringing a motion to remove the judge. That's when you have to necessarily discuss the conduct of judges. Because otherwise, why did I introduce this motion? I want to remove this judge. For that, I have to discuss his conduct. Judiciary has been given the power that you can punish people for contempt. And in India, judiciary is perhaps the only institution in the entire world where judges are appointed by themselves. But still, Constitution envisaged that we need to keep a check on judiciary. And one way to keep a check on judiciary is through removal. Although you are appointed by president, you will remain in office till the age of retirement, which means you will have a security of tenure, which means you will not be subject to the doctrine of the pleasure of the president. At any point in time, the judges can be removed. No, then we cannot ensure independence. But if you do something, and Constitution mentions that there are two grounds on the basis of which the judges can be removed. Crude misbehavior or incapacity. Misbehavior is something that you are all familiar with. Incapacity, maybe when I was appointed as a judge, I was with the sound mind. But then I turned insane, mentally unstable. You may have sympathies with me, but I will not be in a position to do justice to my job. I cannot declare somebody guilty or innocent because I have now been incapacitated. On these grounds, the judges can be removed. So Constitution has provided the grounds of removal of the judges. Misbehavior, incapacity. Constitution has also said what is the majority required. And what is the majority required? Who can remove the judge? President. And this process is same for High Court judge as well as the Supreme Court judge. Who can remove a judge? President. But on the basis of the resolution, which is passed by both Lok Sabha as well as Rajya Sabha, and this resolution should be passed by special majority. And what is this special majority? Majority of 2/3 members present and voting, and majority of the total membership of the House. Which is a very, very difficult majority to achieve. This is the form of majority that is required to remove a judge. And this is mentioned in the Constitution. But how do we prove whether this judge has committed misbehavior or whether this judge has been incapacitated? For that, a law has been passed by the Parliament known as the Judges Inquiry Act 1968. It talks about the procedure. And the procedure is that this matter can originate in Rajya Sabha as well. It can originate in Lok Sabha as well. If 100 members are writing to the Speaker, and if 50 members are writing to the chairperson, that their speaker or their chairperson, we need to remove a particular judge. Now it is the discretion of this presiding officer. This presiding officer may accept your motion or may not accept. This is the discretion. Sir, will it not be misused? We will come to that slightly later. But if the presiding officer accepts this motion, then a 3-member committee has to be set up. Three-member committee. One, there should be a Chief Justice of India or somebody nominated by Chief Justice of India or a Supreme Court judge nominated by Chief Justice of India. Second, Chief Justice of a High Court. Third, a distinguished jurist. For example, when Justice Ramaswamy, one of the judges of the Supreme Court, previously he was the Chief Justice of the Punjab and Haryana High Court, when he was to be removed, the distinguished jurist was Falias Nariman. These 3 members, they will form a committee, and then this committee will have to investigate whether the allegations of misbehavior and incapacity can be proven or not. If this committee says, no, the charges are not proven, Parliament cannot proceed further. That means Parliament will have to drop the process then and there itself. But if this committee says that yes, this particular judge is guilty of misbehavior or incapacitated, in that case, Parliament has to then proceed and go for voting. And if both the houses of the Parliament pass this motion by this majority, then in the same session, if it was the winter session, in the same session, you have to send it to President, and it is binding on the President to remove that judge. Because when this resolution is passed, another technicality, when this resolution is passed, this resolution becomes a statutory resolution. And if you have read Polity well, you would know that statutory resolution is binding on the government. There are 2 other types of resolutions. Government resolution, private members resolution. Those are not binding on the government. The statutory resolution is binding on the government. And when both houses of the Indian Parliament pass this resolution, which is a statutory resolution, then in the same session, the President will have to issue an order. It's binding on the President to issue that order to remove that judge. But till date, sometimes facts are also asked in the exam. For example, once a question was asked in the prelims exam that Office of Profit Act, or the name is Members of Parliament Prevention from Disqualification Act, has been amended 5 times. So some facts may also be important. There have been 6 instances where proceedings against judges and their removal were tried to be initiated, but none of them proved to be successful. The first was of Justice Ramaswamy, who was accused of financial impropriety. Basically, the money which was meant for the Punjab and Haryana High Court, that money was used allegedly by V. Ramaswamy to renovate his personal house. And this is where Kapil Sibal represented Justice Ramaswamy before the Parliament, before the committee of the Parliament. And since in Lok Sabha, the Congress party, since in Parliament, Congress party abstained from voting, hence this majority could not be achieved, and hence this motion to remove Justice Ramaswamy lapsed or was defeated, and he completed his term 1 year later. Second was Justice Sumitra Sen, again on the allegations of corruption. Rajya Sabha passed the motion. It was all set to be passed by Lok Sabha as well, but then maybe Sumitra Sen decided that I should not enter the history books as the first judge to be removed by the Parliament. He resigned. And then there were other instances as well. For example, currently we have the judge in the Supreme Court, Justice Pardiwala. He had made some references when he was the judge of the Gujarat High Court, saying it is the reservation policy which has kept us backward. On that, it was sought that Justice Pardiwala should be removed from his office, but that process could not be initiated. The most controversial one was that of Justice Deepak Misra, who was the Chief Justice of India. The first time when opposition has tried to introduce a motion to remove the Chief Justice of India. Because in January 2017, 4 members of the Collegium, Supreme Court Collegium, Justice Chalameshwar, Justice Kurian Joseph, Justice Madan Lokur, and Justice Ranjan Gogoi, they addressed a historic press conference, unprecedented press conference, which has never happened in the history of independent India. And they said that democracy is in danger. They basically accused Justice Deepak Misra, who was the Chief Justice, of violating his powers of Master of the Roster. They basically alleged that Chief Justice is doing bench fixing. That means important political cases against the government, he is assigning to junior judges, not to the senior judges. And when opposition got to know about this, they tried to introduce this motion before the chairperson of the Rajya Sabha, Mr. Venkaiah Naidu, was the chairperson. And Mr. Venkaiah Naidu rejected this motion. That is why I said this is where the presiding officer has a discretion. All these things are important, and that is why this question was asked in the prelims as well. And let me know how many amongst you can answer this question. Consider the following statements. The motion to impeach a judge. Now, UPSC has also made a mistake of mentioning impeach, but not me, it's the UPSC. The motion to impeach a judge of the Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act. We know the Speaker, the chairperson, they have a discretion. The Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court of India. Constitution does not define and give details. These details are mentioned where? Judges Inquiry Act. If the motion for the impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by majority of the total membership of the house and not by less than 2/3 of the total members present and voting, which means 4 is correct. C, 3 and 4 is the right answer. Right? Okay. Now let's look at another important editorial from the Hindu, hide and seek. Not the biscuit by Parle, but something that Election Commission of India is playing with the election process. Constitutional mandate for Election Commission of India under Article 324 is that this constitutional body has the superintendence, direction, conduct and control of all elections in India, whether Lok Sabha, Legislative Assembly, Legislative Council, Rajya Sabha, President, Vice President, except the local elections which are conducted by the State Election Commission. Over a period of time, there has been an attack on the functioning of the Election Commission of India. One attack is on EVMs. Can EVMs be hacked? The simple answer is no. Even the Hindu editorial says allegations of electronic tampering of voting machines are misplaced and misguided. Because these electronic voting machines, there is one control unit and there is one ballot unit. For example, you are a voter, you enter the polling booth, I am the presiding officer, control unit is with me. Ballot unit is in the voting compartment. This control unit and ballot unit is separated by a 5-meter cable. As soon as you enter, I check your credentials, I press the start button on this control unit, then you can go to the voting compartment and you can press the button on the electronic voting machine and then exit. EVMs cannot be connected to the internet because there is no transmitter, there is no receiver in an electronic voting machine. When there is no transmitter, there is no receiver, that means it cannot be connected to the internet. When it cannot be connected to the internet, which means it cannot be hacked. As simple as that, because what is hacking? I am using a computer device right now. At your home, from your home, you can access my computer system because you can electronically access it, remotely access it because it is connected to the internet. That's what we call hacking. But EVMs cannot be hacked. You may have heard of your phones getting hacked. Pegasus software being used to hack into your phone. But have you ever heard that my calculator has been hacked? You may never have heard. Why? Because calculators cannot be hacked. They are not connected to the internet. EVMs are like calculators. It's just a counting machine. Counter, press 1. Counter, plus plus. In C programming, if you would have ever used that. Just a counter. EVMs cannot be hacked. In fact, there is a solid framework available. Whenever EVMs are to be used in this constituency, and I'm the candidate contesting election from this constituency, either this EVM is opened in my presence or in the presence of my agent. Likewise, there will be all the agents of all the candidates contesting the election, and it is displayed to us whether EVMs are hacked or not. In a sense, how many votes are already registered inside this EVM. We will now clear all those votes. And now to demonstrate, we will press the buttons and we will see whether this vote has been registered correctly or incorrectly. And there is a proper coding available with EVMs. Even the Election Commission of India would not know that this EVM will go to which polling booth. When Election Commission does not know, how can political party or the government hack into these EVMs and manipulate it? In fact, the software which is used for these electronic voting machines, they are burnt only once. That means you can't change the program, the code of this EVM, which means it cannot be hacked, it cannot be programmed. Which means if there are political parties which are alleging EVMs are hacked or mismanaged, they should rather focus on their ideology, focus on their core support, focus on the policies rather than attacking the EVMs. But yes, the election process may be compromised. According to the Hindu, don't hold me accountable. According to media, according to some activists, according to some philosophers, the election process may be compromised. Compromised in the sense, we live in the world of technology where our likes and preferences are recorded. So you are liking this video. Have you pressed the like button yet? Press the like button. And then YouTube will get to know that you have liked this video. And like this, you would have liked a lot of videos. And through this, YouTube will get to know what is your political preference. For example, that data YouTube may share with the political parties because it's a private enterprise. Similarly, what you buy, where do you go, every likes, preferences can be monitored, can be accessed by the state. And this is where the state can get to know whether you are supporting my political party or the opposition. And if I know that you are supporting opposition, I will ensure that you don't get to vote. How? I may use police to harass you. I may use police to arrest you. I may delete your name from the electoral rolls. I may ensure that in your polling booth, there are so many problems with EVMs. EVMs problems in the sense that they are not functioning. They're not hacked, but sometimes they may not function. So we have to get a replaced EVM. Then again, it will malfunction. There may be problem with VVPAT. So ultimately what you will do, forget about voting, I will not vote. So the electoral process may be complicated, may be violated, may be compromised. And these are the allegations against Election Commission of India. And the most serious allegation is, there is a sudden increase in the voter turnout just before the end of the polling. Contrary to what exit poll said, BJP won Haryana elections. Although exit polls had predicted that Congress will win the Haryana elections. Similarly, it is argued by some political parties, opposition, that we were about to win this election, but we somehow lost. I don't know why. Yogendra Yadav, for example, says it goes without logic. How can BJP, which got so badly defeated in the Lok Sabha elections from Maharashtra, could win 3/4 majority few months later in the Legislative Assembly elections? And they all point out too that there is a sudden increase in the voter turnout just before the polling. How is it possible that the figures that you released today, and this was the allegation in the Lok Sabha elections as well, Election Commission of India would release the voting percentage figures today, saying that 61% people voted. But after 2 days or 3 days or a week later, they revise this polling percentage and say 66% people voted. 5% increase. That means lakhs of voters increase. How is that possible? For that, a petition was filed in the Punjab and Haryana High Court by a petitioner, Mahmood Paracha, who asked the Election Commission of India in this petition that you give me the poll papers. Because under the rules, these papers are to be made available. These are in public domain. Papers can be nomination papers. Papers can be the affidavit, anything. But whether this term papers means CCTV footage also, Punjab and Haryana High Court said it includes CCTV footage as well. So share the CCTV footage with the petitioner. Election Commission of India said we can't share. Why? There was Rule 93 of the Conduct of Election Rules 1961, which said all other papers relating to the election shall be open to public inspection. Now this rule has been amended by the central government based on the recommendations of the Election Commission of India. That now only those papers will be available to public inspection, only those papers which are specified in these rules. Sir, what is the difference? Let's compare it to the British Constitution. Sir, Britain does not have a constitution. They have a constitution, it's just that it is not written. Laws are not codified into a single document. But they have a constitution. Sir, do they have fundamental rights as well? They have. But we can say the foundation of their fundamental rights is negative. Negative in the sense, we have fundamental rights under Part 3 of the Constitution. right to equality, right to privacy, right to life, right to religion. These are the fundamental rights. Right or wrong? Is right to vote a fundamental right in India? No. Is right to marry a fundamental right? No. Is right to interstate trade and commerce a fundamental right? No. Is right to work a fundamental right? No. Only the rights which are mentioned under Part 3, these are the fundamental rights. In Britain, everything is a fundamental right unless and until it's expressly prohibited by the law. Right to marry is a fundamental right in Britain? Yes, because law does not criminalize marriage in Britain. Right to privacy is a fundamental right? Yes, because there is no law which says right to privacy is not a fundamental right, it's not a right. Right to work, right to trade, right to vote, everything is fundamental right. Right to murder? No. Why? Because it's explicitly prohibited by law that you can't murder. Right to commit theft? No, it's not a fundamental right because it is prohibited by law. So whatever is prohibited, this is not the right. Apart from that, everything is your right. That is why we say British Parliament is sovereign, in a sense that British Parliament can do anything. And as British constitutional expert D. Lolme said, British Parliament can do anything except convert a man into a woman and a woman into a man. Homophobic statement because you are excluding transgenders, but you need to understand the context. It was written centuries ago. But be that as it may, previously the rule said every paper is available to you for public inspection. Every paper. Now the amended rule says only these papers which are mentioned in the rules are available. If every paper is available, that means CCTV footage is also available. If only these papers are available which are mentioned in the rules, and in these rules there is no mention of CCTV footage, which means it will not be available. But what is the CCTV footage? What exactly would happen because of this? Why is ECI objecting? Let's look at the details. I told you that there is a sudden increase in voters when it comes to close to voting, right? The best way to figure out whether these voters are genuine or not, this is to check the CCTV footage. There is Form 17A. If you are a voter outside the polling booth, you have to mention your details. This Form 17A is the register of voters. That means every voter who comes to the polling booth signs this register. This is Form 17A. But then we have Form 17C, which is shared with the people as well, which is shared with the candidates as well, which is shared with the polling agents as well. What is the 17C? It records everything. What is the identification of the EVMs which are used in this polling station? So that tomorrow when the counting takes place, we can get to know that in this polling station, this was the serial number. Why are you opening another serial number? This is a check. Total number of electors assigned to this polling station. Whether it is 1200 or 1500. What is the total number of voters assigned to this polling station? Total number of voters who enter the polling booth by signing Form 17A. But even if you have filed Form 17A, you enter the polling booth, maybe you are not allowed to vote. Maybe you refuse to vote. Although Supreme Court had said in one of the petitions that this is unconstitutional. Why? Because it violates secrecy of the vote. If I am a voter, nobody should get to know whom I voted for. Because if somebody gets to know who I voted for, then maybe the political party will victimize me. If this political party comes to power, but I did not vote for this political party, I voted for the opposition, they will kill me. Or they will not accept my grievances. They will not take care of my problems. Or they will victimize me. To ensure this, we have secrecy of the vote, which is one of the most important sacred things in voting process. But one aspect was, if I have filled my details in Form 17A, which means I have entered the polling booth, now when I enter the polling station, I decide not to vote. I have to mention these details that I am not voting. And when I say I am not voting, that means this detail can be shared with others as well. That means people will get to know that here is an individual who has not cast his vote. Are you not violating my secrecy? Supreme Court said in one of the cases that it is unconstitutional. But even then, Election Commission follows this. There has been a lack of awareness on this particular aspect, but that's besides the point. Form 17C contains everything. Number of people who decide not to record their vote, number of people who were not allowed to vote, number of test votes to be deducted, and the total number of votes recorded per EVM. Test vote in the sense I told you that when the voting will start, the polling agents of candidates, they will be demonstrated that, see, to give you satisfaction, we will vote for A, we will vote for B, we will vote for C. These are test votes. And then we will count them as well. And we will see that whether votes are indeed registered for you or not. It should not be like a member of the Aam Aadmi Party later saying that I contested election, but the number of votes registered in my favor were 0. Okay, let's assume that everybody is a Modi Bhakt, but my family voted for me. Where is my vote? Where are their votes? Or even if we assume that my family is also inherently the supporters of Mr. Modi, but I voted for myself. How is the number of votes in my favor 0? But that person was lying. Maybe he wanted to deliberately tarnish the image of electronic voting machines. So those test votes are also to be deducted so that we can now get to know total number of recorded votes. Right? So if there is an allegation that there is a sudden increase in the number of voters, for that we should check 17C. And then we should check CCTV footage as well. That whether these are the people who indeed went to vote, or were they not allowed to vote and someone else voted on their behalf. For that, CCTV footage becomes important. Election Commission of India says this CCTV footage would violate secrecy and it will be misused in Naxal affected areas, in separatist areas, in areas where there is separatism, for example, Jammu and Kashmir. And then these voters will be victimized. But that is not a sound argument. Why? Because there is media which is capturing footage of voters as well. And people will get to know who are these people who are waiting in queue outside the polling booth, waiting to exercise their right to vote. So if that is available inside the polling booths voting, why is that not available? Election Commission of India says, but because of deep fakes, this data can also be manipulated. So it will compromise the election process. This Hindu editorial says, at a time when the credibility of Election Commission of India is at its lowest, transparency is the only antidote. Because as they say, sunlight is the best disinfectant. Be more transparent in your functioning. And the Hindu editorial says the timing of this change in the rule is also suspicious, because this came at a time when Punjab and Haryana High Court directed the Election Commission of India that with the petitioner you share the CCTV footage as well. And that petitioner has said that even if you have changed these rules, these change would not apply retrospectively. So I will still challenge before the court and I will seek the details of the CCTV footage of the Haryana elections. But be that as it may, this is the topic that you need to understand, and that completes our another topic. Any questions? Okay. Building the Future versus Remaking the Past, written by Raj Mohan Gandhi. He was also the biographer of Sardar Patel, wrote a beautiful biographical account of the life of Sardar Patel. What is the crux of this article written in the Hindustan Times? I recently conducted an interview of a UPSC panelist. So Miss Aruna Sharma, who conducts interviews of the selected candidates, I took her interview, basically asking her what should be done, what should not be done by the candidates preparing for this exam, preparing for the interview, how they should be dressed. If you have not watched that video, you can watch it. It's available on our YouTube channel. But there are questions that are asked in your interview regarding current affairs topics. And I asked her specifically, you may be asked about what is your take on the Places of Worship Act, on which she replied that we should categorically state that India is a secular polity. We believe in constitution and this law is there required. But sometimes you will have to give a different answer as well, because everybody would give the same answer. Can we draw an answer to this question from a philosophical text? For example, Mahabharata. For example, Bhagavad Gita. That's something that you can understand if you read this beautiful article written by Professor Raj Mohan Gandhi. You know what is the conflict. We've discussed that at least twice in the previous two UCAN sessions. Places of Worship Act. And now what the Supreme Court has done, it has stopped all the proceedings under Places of Worship Act. Or it has stopped all the proceedings where petitions were filed asking that this is a religious place where currently there is a mosque, but previously there used to be a Hindu temple, and we want to ascertain the origin of this temple or this religious place, which would be violating Places of Worship Act of 1991. But the Act of 1991 itself has been challenged before the court on the grounds that it violates Constitution. That arbitrarily the date 15th of August 1947 is being put out as a cut-off date. That it violates judicial review, which is part of the basic structure. That it violates Article 25, which is right to practice your religion, profess your religion. And now a 3-judge bench of the Supreme Court will decide whether this Places of Worship Act 1991 is constitutional or not. And Mr. Raj Mohan Gandhi argues that it is this judgment, once it is given, this case will be viewed as Hindu versus Muslim. And once the judgment is given, one will be projected as the winner and the other will be projected as the loser. And that is where this judgment becomes important, because this judgment will have a clash between two ideas of India. One which believes in equality and other which believes in majoritarianism. Not my words, words of Mr. Raj Mohan Gandhi. Don't agree with him, ask him to clarify, not me. And Mr. Raj Mohan Gandhi argues that the judgment will also influence the perception of the world towards Hinduism. Because how does world perceive Hinduism? For that, let's go back to the World Conference on Religions in Chicago, way back in 1893, which was addressed by Swami Vivekananda. He did not say that we respect all religions or we tolerate all religions. What he said is that all religions are true. We accept all religions are true. But then few years later in London, he accepted that yes, the religion that we practice in India may not be equalitarian. We discriminate on the grounds of caste. But he had a hope that when he spoke in London, he said democracy will be accepted by Indians. Unity and equality will be embraced by the Indians. Because he was aware that there are divisions within our society. And that's when in 1949, when the founding fathers of our republic gave us a constitution, that constitution spoke of a secular India. An India where there is liberty of thought, belief, worship, where there is equality, where there is non-discrimination. And it is that constitution which we have implemented over the last 75 years. And Mr. Raj Mohan Gandhi argues that although there have been attacks on the constitution here and there, but more and less, by large, we have seen the political class embracing and accepting this constitution. But some documents will be accepted only if the majority accepts it. What if the majority turns against this constitution or the secular ideals of this constitution? Then this constitution will lose its moral force. Constitutional promises become dead letters when resentment animates a large number of people. When large number of people, they resent a constitutional promise. And when the state fails to control violence. And that's what Raj Mohan Gandhi argues happened in December 1992 when car sevaks demolished the Babri Masjid, where the state refused to protect that mosque, despite the fact that the government then had given a promise, a pledge, an affidavit before the Supreme Court that we will ensure that this Babri Masjid is not demolished. But when that Ayodhya verdict was given by the court in 2019, the Supreme Court paved way for the construction of the Ram temple, but at the same time said that it is this Places of Worship Act which has ensured secular credentials of India. The issues of the past, the mistakes of the past cannot be corrected through courts in future or in the present. Because from the purview of the Places of Worship Act, that Ayodhya Ram temple, Ram Janmabhoomi place, it was kept out of the purview of the Places of Worship Act. But now various petitions are being filed where the petitioners are asking that survey should be conducted to see whether that religious place was a temple previously in the past. And Raj Mohan Gandhi argues that we must learn from history is that when campaigns to rearrange the past are launched, they injure the present. What we need to reconcile. And for that, Raj Mohan Gandhi argues that look at the epic Mahabharata. It was basically a revenge, a fight at Kurukshetra between the Pandavas and the Kauravas. Who gets to ascend the throne? So it was full of revenge. Even then, one of the dramatic scenes of Mahabharata was when the author of Mahabharata, Vyasa, when after the Kurukshetra war got over, hardly anybody survived. All the heroes are dead. Everybody has vanished. And to those who were grieving, Vyasa, he appears himself and tells the mourners, I shall dispel your grief. And then those who were dead, they were brought alive from the rivers of Bhagirathi. And when they were brought alive, they were cleansed of hate. They were cleansed of jealousy. Father meeting son, son meeting daughter, so on and so forth. Everything is now reconciled because everybody is cleansed of hate. But then by that dawn, the dream of reunion was over. All those who were brought back to life from the river Bhagirathi, now they are thrown back into the depths of this river. So although it was short-lived, but it tells us a moral story. And that story is, we have to cleanse ourselves of hate and jealousy. That's how we can dump the past and not try to correct the mistakes of the past in the future. Because whenever history is rearranged, past is rearranged, it damages the future. According to Raj Mohan Gandhi, not me. Then he tells another story Another reconciliation scene is presented to us after the war is over, after the Kurukshetra war is over, when Arjun goes to proclaim the Pandav supremacy. And he enters where? Sendhava territory, which is the Sindh. There he meets Dosala. Dosala was the sister of the Kauravas, and the Kauravas were defeated. And Arjun is asking Dosala, where is your son? Dosala, she was married to a Kaurava warrior who was killed by Arjun. And it is argued that unceremoniously or in a wicked manner, Arjun killed the husband of Dosala. And now Arjun is asking Dosala, where is your son? And who is the small boy with you? Dosala says, my son, he also died because he could not bear that you killed his father. And Arjun is now looking down in despair, mourning. And Dosala is then asking that this boy is the same person, or this boy is similar to what Parikshit is to your son Abhimanyu. Abhimanyu, who was the son of Arjun, he was killed. He was killed in that Chakravyuh, from where he could not come out. And through deceit, he was killed. He was a fantastic warrior, but through deceit, he was killed. Abhimanyu's son is Parikshit. So Parikshit is Abhimanyu's son. This small boy, who is with Dosala, is the son of her son, who died because he could not bear that Arjun had killed his father. Arjun is weeping, but now this lady, Dosala, is asking that you will not refuse me. I have come to plead for the lives of my people. And this is where Arjun embraced Dosala, asked her to return to the palace, and then he made with the people of Sindh. He made peace with the people of Sindh. So reconciliation. Give up what has happened in the past. Move ahead. Our constitution is forward-looking. So maybe these instances of reconciliation, which have appeared in our historical texts, our moral stories, can be cited in your interviews if you're asked a question about this topic. Okay? Won't citing this backfire? No, because these are not religious texts. These have some moral stories, not necessarily religious texts. Let's look at the last column that we have to discuss from Hindustan Times. Law on marital cruelty needs a robust backing. And this is surrounding the unfortunate suicide by Mr. Atul Subhash, who killed himself because he alleged torture, extortion at the hands of his ex-wife as well as her in-laws. And then we saw another instance which happened in Delhi, where the owner of a cafe killed himself because, again, he was alleging mistreatment, harassment at the hands of his wife and the in-laws. And this larger debate is now on Section 498, capital A of Indian Penal Code, which talks about cruelty in marriage by the relatives of husband. So the argument is that these laws, which were meant to protect women, the women have now weaponized these laws for their ulterior motives. And they file these false cases against the relatives of the husbands and torture them. And that's ultimately how some of them end up taking their lives. And there is a greater demand now that this Section 498, capital A, should be deleted, because similar provision exists in the Bharatiya Nyaya Sanhita as well. This column, however, argues that look at the statistics. Although National Crime Record Bureau, it tells us that the conviction rate in these domestic violence cases or under Section 498 capital A is hardly 12%. In 2018, it was 13%. So it is consistently coming down, but the data that you see might give a misleading sense, might not convey the real picture. Why? Because 32% of the married women in India, they face violence at the hands of their husbands. Yet only 14% seek help. So of all the cases which have reached the court, these are not the all cases. Majority of these cases don't go to the courts, don't go to the police. And something else. For example, during the Second World War, a lot of planes were bombed, attacked, and then these planes crashed as well. Some of these planes could not crash and they reached the destination, and then data analysts were called to see how we can prevent the crashes of these airplanes. And they looked at these images. So aircraft is coming, they are under attack by bombs or weapons, but then some of these aircrafts, they survive, they reach back the destination while others don't. If you look at this image on the screen, red spots are where there are attacks made by the bombs. That means these are the areas where bombs have hit, ammunition have hit the airplanes. When data analysts were called, they looked at this image and said, we need more protection here in these areas. Because if these are the areas which are attacked, we need more protection in these areas so that we can save these airplanes. One Hungarian mathematician, statistician, Mr. Abraham Wald, he looked at this image differently. He said, you don't have to have extra protection for these areas. You should have protection for areas which are not hit. I said, why? Because even if these areas have hit, it doesn't cause the crash, because even then these planes reach us back. It is the areas which have been hit which causes the crash of these airplanes, because these planes which have reached back, they were not hit in these critical areas. That is why they have survived. So we need more protection here. So it depends on how do you look at the data. Even if the data says that 14% or 13% or 12% conviction rate in 498 capital A cases, but that may also be because the police has conducted shoddy investigation, and unfortunately these cases are not decided by the courts in favor of women. It may also be possible that genuine cases are not accepted by the police, and the cases investigated by the police is done in such a shoddy manner that you speak in favor of the accused. So it depends on how you look at the data, and the data is this, that 14% alone women who are facing spousal violence, they approach for help. And Miss A.L. Sharda, she is asking for something very interesting. There is Atrocities Act. If you are accused under the Atrocities Act, you are immediately arrested. It's a non-bailable offense. Right? That means no bail will be given. Immediately you are under arrest. And maybe after later it is proven that you are not guilty. In 2018, in a case known as Subhash Mahajan, Supreme Court said that this law has been misused because the conviction rate is less. And when the law has been misused, we need to prevent the misuse of this law. And how do we prevent the misuse of this law? No automatic arrest. If you're accused under Atrocities Act, no automatic arrest. There has to be a preliminary inquiry. Let the police conduct an inquiry to see if prima facie there is a case of atrocity. This may be a case of personal rivalry as well, and you are clothing it with Atrocities Act. We will not arrest you. And then there should be a written permission by the superintendent of police. Only after that you can be arrested. The accused can be arrested. When this Atrocities Act judgment was given, Subhash Mahajan judgment was given by the court, there was a lot of protest. There were a lot of protests in India. Couple of people also lost their lives. And then what happened? Section 6A was added to this Atrocities Act. And status quo ante was restored. That means the allegation was that Supreme Court has diluted the impact of the Atrocities Act. Parliament got together, amended the Atrocities Act and restored the status quo ante. That means before this judgment, what was the status? That status was restored, which means automatic arrest, immediate FIR, non-bailable offense, no need to conduct a preliminary inquiry. No need for a written permission by the superintendent of police before you can arrest somebody who is accused of committing atrocities under the Atrocities Act. So when there was a movement launched by people to restore the protection under the Atrocities Act, and now there are similar demands by the people to revoke or to amend or to quash these protections for women under 498A, we don't see a similar movement launched by people. So for similar set of people, both have been discriminated against throughout the history, SCs and STs as well as women. For one section of the society, you see a movement asking for the restoration of that protection. But for women, you are completely turning a blind eye. So we need similar protection. We need a robust backing. Domestic violence was viewed as a private matter. Caste violence was viewed as a matter concerning the society. The author writes that domestic violence is no longer a private matter because it is the manifestation of the systemic inequality in the society. Yes, laws have been misused. There will be people who will misuse the law, but that doesn't mean you throw the baby out with the bathwater. That doesn't mean you will abolish the law, amend the law, strike down the law. That is what the author is trying to convey. Law on marital cruelty needs robust backing. Because there were allegations of misuse both for Atrocities Act as well as Section 498 capital A. Court recognized ultimately, because when this Atrocities Act was amended, Section 6A was added. Even this amendment went to the court. The Supreme Court upheld the power of the Parliament that you can amend this law. The Supreme Court upheld that just because the law is misused, that doesn't mean you will have to dilute that law. If similar protection is available to Atrocities Act, the similar provision must be retained for the domestic violence or Section 498 capital A. Cruelty at the time of the marriage by the relatives of the husbands. There was another allegation of misuse where there was husband and wife. They wanted to separate. Husband is in a relationship with another woman. And now this wife files a case under 498 against the girlfriend of this husband, saying you are the relative. And the court said, under no stretch of imagination can we call the girlfriend of a man as a relative, which can come under the Domestic Violence Act, which can come under this Act of 498 capital A. Okay, that's about it. That's something that we needed to discuss today. All the important articles from December 10 till 31st December 2024. related to Indian polity have been covered in this session from sources such as the Hindu, the Indian Express, the Hindustan Times. And with regret, I will reiterate and inform you again that henceforth, all these UCAN sessions shall be available exclusively on the Unacademy app, exclusively available to those who have enrolled in this course. And should you wish to enroll in UCAN, I would say that there is a much better option. You can enroll for GS subscription, where you can get GS, CSAT, UCAN, Hindi, bilingual, English classes, everything with one subscription, and that too only at 23,499. If money is not a problem, then please consider joining this course. I am 100% sure you will be benefited by this course. And plus, 23,499, yes, for a large number of people, would be a big sum. But if you can compare it with, for example, the fee which is charged by coaching institutes in Delhi, this would be your expense every month. Apart from the lakhs of rupees that they will charge you as tuition fee, every month for your boarding, lodging, food, everything else, you will be spending more than 20,000. So your cost of this subscription for 1 year is less than the cost of your 1 month expense in Delhi. If you can compare it that way, then this is India's most affordable program. That's it from now. If you have not yet pressed the like button, do press the like button and drop in your comments as well, because there will be students tomorrow who will say that you're lying. Your enrolled students never asked that you should have these programs exclusively available on the Unacademy app. This is something that you are making out of the thin air. Please let them know in the comment section that you wanted these sessions only on the app. Thank you for watching. See you again when I see you. Bye-bye. Take care.